as I said, the first part will be presented by me. I will talk about the crisis legal regulations regarding rights of person arriving from Ukraine, of course, from 24 February 2022. What is basically the crisis legal regulation? This is the most important issue to just give you a background what I will be talking about. So those are the special legal acts which do concern the situation which we are dealing right now, and they are being issued both on the ground of the EU law, but also on the ground of our Polish legal system. And I would like to tell you a little bit about both those areas, as they are both very important when it comes to considering the situation of the employees who are coming from the Ukraine right now to the territory of Poland, but not only, because what we all have to know is that people who are coming to Poland are not necessarily coming directly into Poland from the territory of Ukraine, which is also very important when it comes to the situation, to the legal situation which we have in Poland right now. So the most important legal act which we have to be aware about is the Council implementing decision from 4th of March 2022, and of course you can ask what is the decision implementing. So it is implementing the directive from 2001. So there can be a concern why in 2001 the directive was issued and now it is being implemented. So the directive from 2001 was issued after the crisis, both on the territory of ex-Yugoslavia and also after the crisis which EU had to deal with after the humanitarian crisis caused by the war in Kosovo. So in 2001, European Union decided to prepare a directive, but this directive was not enforced. To make this directive enforced, each time a special decision has to be issued to implement, to make this direction to be alive. And such a decision was issued on 4th of March 2022, so very soon after the war on the Ukraine started. What is important when it comes to the scope of the decision of EU is that it basically shows us who is being covered both by the decision and by the directive which it implements. So the personal scope of the decision is crucial when it comes to deciding who gets the special treatment based on the directive from 2001. And as you can see on the slide, I put here some only of this personal scope, only a part of the personal scope of the decision which implements the directive from 2001. But what is the most important issue here is that the decision basically shows us who can be the person covered by both the decision and the directive. And of course, those are Ukrainian nationals, but what is important, residing in Ukraine before 24 February 2022. And also those people have to escape from the Ukraine starting at this date. So what is crucial also for people who now deal with all the immigration issues concerning Ukrainian citizens is that, for example, Ukrainian citizens who during 24th of February were on the holidays, on the vacation somewhere around the world, they are not the part of the personal scope of both the decision and the directive. So they are not covered by the decision and they are not covered by the directive. But on the basis of our Polish law, they do have some special rights right now on the labor market. I will tell more about it later on. But what we have to remember is that both this directive and the decision is very special legal tool which do automatically cover all the people who are being put into the decision. So not any other legal act has to be issued to cover people who are being covered by the decision, to give them special rights. Those people automatically get the special treatment based on the EU law. So, when it comes to the directive from 2001, which is being implemented by the decision from the 4th of March, it covers people who are mentioned in the decision with the special treatment, and it gives them a special status of people who get so-called temporary protection. And this is the most important, that those people, as I said, automatically got the temporary protection based on the EU law. But also what derives from both the directive and the decision is the right to each member state to grant some special additional rights to two groups of people. First, those rights can be granted to people who are being covered by the decision. And secondly, those rights can be granted to people who are not being covered by the decision. So here the member states can spread the protection to people who are not being covered by the decision as such. Poland somehow did use this special tool from deriving from the directive, but not necessarily in the direction which the directive means. So now what is important also is the period of the temporary protection, which is being granted both by the decision and the directive. So this special status from people who escape the territory of Ukraine is being granted for the period of 1 year. It can be then modified into 2 periods of additional 6 months, but right now it is being granted for the period time of 1 year. And so when it comes to what we are dealing with in Poland, we do have the special act, special law, which covers people who did escape the Ukraine, but as you will learn very soon, not all of them, and also the scope of our law is narrower than the personal scope of the decision of EU. But it doesn't, of course, mean that people who are not mentioned into our special act on March 12th are being somehow deprived of the status of people who are under the temporary protection. Those people, of course, do have their rights on the ground of Polish law, but not on the ground of the special act on March 12th. So we have two categories of people: those who are being covered by the decision and who are being covered by the special act. And we also do have other group of people. Another one, those are people who are being covered by the decision, but are not covered by the special act. And as I previously said, the EU law gives each member state the right to grant special rights to the people who are covered by the decision, and this is what happened in Poland. But what is important, as I said, those special rights are not being granted to all of the people who are covered by the decision. So now let's look through the act of March 12, the special act, who is being covered by its stipulation. So first of all, those are Ukrainian citizens only. So third nationals or people without any nationality are not being covered by the special act. So first, only people who are Ukrainian citizens are covered by the special act. And what is important, and what is now the work on the amendment in progress, is that only people who came directly from the territory of Ukraine to Poland are being covered by the special act. That basically means that if Ukrainian citizens first cross the border, for example, with Hungary, and then by crossing other borders came into Poland. So this travel was not directly to Poland, it was indirect. Such a person is not, according to the law which we have right now today, it's not covered by the special act. I'm imposing an impact on telling you that it is today's state of the legal situation, because, as I said, work on the amendment are in progress, and our parliament is now working on changing this rule. So all people who are coming to Poland, also those who came indirectly, are supposed to be covered by the special act. What is the second obligation which has to be fulfilled by people who are covered by the special act, is that they are supposed to come to Poland legally. So of course, all those people who came illegally to the Republic of Poland, they are not covered by the special act. But what is very important right now, according to the situation which we have on our borders, it is very hard to find who came to Poland legally and who came illegally, because a lot of people who are crossing our border do not get any confirmation about the fact that they actually crossed the border between Poland and Ukraine. But this is one of the stipulations. What is also important, what I've already also mentioned in the connection of EU law, those people are supposed to come from the Ukraine, not from any other countries. And of course, only people who came after 24th, starting from 24th February 2022, are covered by the special act when it comes to special status which those people have, because as you will learn in a few minutes, also people who already were in Poland starting from 24th February, before 24th February 2022, do have some special rights on the Polish labor market, but I will tell about it in a minute. And also, what is the other stipulation? Those people have to come in connection with military operation. Right now, we do presume that all the people who are coming from the territory of Ukraine are coming in the connection with military operations. So here, nothing has to be proven by people who are coming that they actually came because of military operation. And last but not least, also those people have to declare their intention to stay in the Republic of Poland. And how do they do it? They do it during the registration in the offices. So those are the stipulations which have to be fulfilled by people who came to Poland directly from Ukraine because of the military operation there. But as I said, some people who already were in Poland are also covered by this special act. And here, when it comes to what is most important for employers who do employ Ukrainian citizens, is that right now we can say that we just forget about all the procedures which we had before the war. Of course, they can still be used, but now the work of Ukrainian citizens can be, let's call it legalized, but this is not even the process of legalization. Just with the employers notifying the relevant district employment office about the fact that such an employer or entity providing the work to the foreigner, about the fact that such an entity employed Ukrainian citizen. And here, as you can see, this special procedure deriving from the special act can be used both to the people who are covered by the statute, so who did fulfill all the requirements which I was talking about, but also this special, very simple procedure can be used to all Ukrainian citizens who are legally residing in Poland. So also those who already were in Poland before 24th of February 2022, and also those who came to Poland indirectly. They can be employed with this super easy procedure, and also those who, for example, came to Poland from holidays, as I told you. So they didn't come exactly because of the military aggression. So all those people who are not being covered by the stipulations of special act are being covered by its stipulation, but only with regards to the, or mainly with the regard to the super easy procedure concerning legalizing the work. So here the employer only has to notify the relevant district employment office about the fact that such an entity employed Ukrainian citizen, and this notification has to be made within 13 days from the date of the starting work of the Ukrainian citizens. So all of them, to all of you who already know the procedures of legalizing work of foreign employees, you do know that this one is really very easy when it comes to comparing it to what we know from before this special act and this situation which we have right now. And I will right now also like to encourage all of you to get more information about our studies, which are divided to gain more knowledge about the procedures of legalizing both stay and employment of the foreign citizens. We will start the second edition in October this year. We already are in the first edition. So if you are willing to get more information, please just follow the link, and there you can find some precise information about our studies, and that is it from me. Now I will pass the screen to Wojciech, and during his speech, I will be there for you to answer any questions from the chat. Thank you very much.
Thank you, Isa. Well, now we will pass on to part 2, which will be dedicated to business in Poland tax-wise. So we'll be focusing on tax side of transferring, setting up business in Poland. We'll be focusing obviously on what kind of business structures, what kind of business vehicles are available now under the special measures to the Ukrainian citizens. We will also touch base upon the Polish tax new deal, which is obviously a big factor in all matters that are related to taxes nowadays. And then we'll move to savings models, which is basically the most important part of what we are going to talk about today, because in every business environment, it is the business advantage that you are going to get if your business costs less than the person next door that is running a similar business. So transferring and setting up business and available options for the citizens of Ukraine. Before the 24th of February, there was limited access for entrepreneurs that wanted to set up a business in Poland. Citizens of Ukraine were considered a third-party citizen, third country citizens, in difference to EU or EEA and Swiss citizens who were full access to Polish market when talking about setting up business in Poland. So before the 24th of February, the citizens of Ukraine could set up a limited partnership, could set up a limited joint stock partnership, limited liability company, or a joint stock company, also in its new iteration of simple joint stock company. All of these entities are subject to corporate income tax. So all of them are corporate income tax payers. And basically, as per the general rule, we have in each of them a two-level taxation system. So first, it is the partnership or the company that is being taxed, and then it is the partner or the shareholder that is being taxed. So it is not ideal. In limited partnership and in limited joint stock partnership, we could see special measures for unlimited partners to basically have an effective tier 1 level taxation, but still it was a limited taxes. However, since 24th February, things have changed, and now Ukrainian citizens have basically the same access to kinds of businesses they can set up in Poland as the Polish citizens. So if you are an Ukrainian citizen and if you are subject to special measures under the special laws, you can also set up a sole tradership and so become a sole trader, which is jednoosobowa. Oh, sorry, there's a typo here. It should be jednoosobowa and not jednodobowa. Jednoosobowa działalność gospodarcza, or JDG. Or you can set up a general partnership, or you can set up a professional partnership. Basically, a professional partnership is a type of general partnership with some tweaks, and it's directed at professionals such as attorneys at law, tax advisors, architects, and a dentist, and so on. But sole tradership is basically a type of legal vehicle that it was a most common choice for Polish entrepreneurs. But it was denied to citizens of Ukraine, so they could not actually become sole traders in Poland. Now that has changed, so to all of you who can benefit from the new special law, you can now set up a sole tradership in Poland and benefit from all the rules that apply to the sole tradership. The most common choice for foreign entrepreneurs is basically a limited liability company, and this is what we see mostly as the first choice for what used to be the first choice also for the citizens of Ukraine. However, many things have changed with the Polish tax new deal. And now what we see is that the most sought after alternatives for these most common choices are still sole tradership, but with changed tax approach, and a limited joint stock partnership for those whose scope of business is too big to basically to benefit from the measures that are available to sole traders. So limited joint stock partnership for the bigger companies, for the bigger businesses, and sole tradership for the smaller businesses would be the first and simplest answer of what kind of options you should be looking at when setting up a business in Poland now after the special law has become effective. The Polish tax new deal is the biggest tax reform in decades. Make no mistake, it's huge, it's varied, it touches on pretty much every single tax there is and on all the most important ones. And it basically, it's a new deal, like in the cards. We know the cards have been dealt again, and we have to adjust to the new system. It starts with the overhaul of the entire healthcare contribution system, because before the 2022, the healthcare contributions were basically deductible from the tax. So before you paid tax, before you had your tax to pay, you could deduct the most of the healthcare contributions that you paid beforehand. Now you can't do that. So given the fact that in most situations the healthcare contributions are at the level of 9% of the basis for settling them, and the basis for the base for the healthcare contributions is basically similar to the tax base. It means that because of this overhaul of the healthcare contribution system, we are seeing an increase of taxes. Maybe not everywhere it would be 9%, as I will comment on in a minute, but we'll seeing a huge increase of tax bill, especially when it comes to sole traders. The Polish businesses are now in the crisis mode and have been for the last half of the year, so to say, because obviously since the 1st January of 2022, but also before that, already in 2021, there was a lot of talks, a lot of discussions how to adjust the business before the tax new deal, the Polish tax new deal becomes a new reality for us all. And what the Polish businesses had to deal with was the minimal tax, which is something new, that it's the tax which you are paying if you do not have any net income, or if you have a tax loss. There is a new withholding tax regime, which basically was put on hold for a couple of years, and now it finally has become effective. There are new or changed tax reliefs, which give some new incentives, but there is a limited information on how to actually implement them for the time being. There is an entire new idea of something called hidden dividend, and there are dramatic changes to tax depreciation when it comes to tax depreciation of residential buildings and their parts. So, but these are the things that you should think about further down the road, and this is just to just give you more or less the better understanding how huge the Polish tax new deal is, because what mostly affected businesses, as I said, were sole traders, or the change that they were looking at, it was that before the tax new deal, the most common approach for the sole traders was to choose a flat rate taxation of 19%, and then you could also choose the lump sum social security contributions. But that has changed. Now you add the healthcare contributions to your tax, basically. So basically it increases your tax bill. So if you chose the flat rate tax. It is the only situation when the healthcare contributions are at a different level than 9%, which I mentioned before. For those who tax their income at 19%, for those who opted to use the flat rate of 19%, the healthcare contributions are at 4.9. Whatever was the idea behind it, it's obscure, and there was a lot of talk what would be the level for those who chose the flat rate taxation. So at the end, the 4.9 was chosen, and so the effective tax rate increased from 19% or 19% plus a little more, because we had a lump sum healthcare before that, and so it increased from 90% to almost 24%. So you can see that just in terms of percentage points, it's a almost 5% increase. So it's huge, basically, because we are saying it's a like 25% increase of taxes. So a lot of businesses here in Poland, which the word sole traderships, had to overnight change their business model. And obviously, when you are thinking about sole traders, the first idea that comes into your mind is somebody like myself, like a tax advisor, or my estimated colleagues here, who are qualified lawyers. You may think of dentists, of architects. You may think of other people who are professionals. And this is all obviously true, but most of sole traders were professionals who had just one person business. But I will tell you that there were a lot of sole traders who had huge companies, who had huge businesses, and who were actually generating millions of Polish zlotys in revenues year on year. So they were faced with the huge increase of tax bill, and we will see today how they were trying to deal with it and how they are trying to actually have some tax savings at the end of the day. There are also a lot of new measures when dealing with employment agreement or agreement of mandate under the Polish tax deal. Those who are employees are basically, well, maybe not most of them, just very few of them are paying for or financing the Polish tax deal. Most of the employees are covered by special new measures, such as increased free of tax amount or other new measures. However, to implement all those new measures and to actually find your bearings in this new environment when you have all of these new measures is very taxing on the employees. This is something very new to them, because historically employees didn't have to really care about their taxes. They just, was the part of being an employee. They just came to a company and everything was being done for them, including their taxes. Now the employees in Poland have to actually think a lot of what measures they want to implement, what measures they want to use to their benefit. They have to calculate for themselves what is basically the best solution for them, and this is something that they haven't faced ever, basically. Another group that is paying for the Polish tax deal, well, I said that the employees are not paying, most of them are not paying, but those who receive the highest remunerations are those who are already financing the Polish tax deal. But this is just a small group comparatively. But we know that one group that is paying for the tax deal, what is supposed to pay for the tax deal, are obviously sole traders. The other group are those who render services under an agreement of mandate, so under umowa zlecenia. And here we are seeing some strange, so to say, solutions that were implemented by our ruling party, because the situation of the employees and those who are working under an agreement of mandate used to be pretty similar in most cases. Now it's very different under the Polish personal income tax law. And we can see that those who work under the agreement of mandate are very much in a very much disadvantageous situation now. There are some special measures that are targeted to them to support them, but they seem not to work that well, so to say. But again, as we will see also today, there are some solutions that we can implement to also help those who of you, those entrepreneurs who actually hire under the agreement of mandate. So how to benefit? How to benefit from the tax new deal? Because this is one of the biggest questions. Because we see that it's problematic. We see that it's a huge problem to be solved. But as in every problem, there are several solutions, obviously. So the first things first is to choose an optimal business structure, tax-wise, from the start. So when you come to Poland and when you are already in Poland and you decide on setting up your company or setting up the business, you have to consider several factors. You have to consider the business size. So how much are you gonna earn year on year? Are you going to be dealing with trade, with production, with services? How many people are you going to hire? So this will all translate into a given income. So if your annual gross income threshold is over, if your annual gross income is over 2 million euros, you will basically be looking not at the sole tradership, but at bigger or at companies, or for example, limited joint stock partnership. Also, when you are surpassing the 2 million euros threshold, you cannot benefit from the special corporate income tax rate of 9%. So because we have, as you already know, the two levels of the corporate income tax for small taxpayers, which is 9%, and for the big taxpayers, which is 19%. You have to consider the type of business activities that you will be conducting. Sometimes it will be good to have one set of rules being applied to you, in other situation another. You have to see what taxes and contributions will be payable in your situation, because you don't want to see your margin to be basically eaten up by the tax and contributions. You have to consider whether you need to have the profits readily available every day. So to say, do you need to transfer the profits to your private pocket as you go, or rather you're going to be reinvesting it? So, for example, when you are speaking about sole tradership or the general partnership, we can see that the effective tax rate can be as low as 8.5%. We'd be looking at lump sum taxation and lump sum healthcare contributions. And with sole tradership, when you are setting up a new business, you can also have also an exemption from the social security contributions, which is for 6 months, and then after this 6 months, for another 2 years, you can be looking at the super reduced social security contributions. So there are lots of different things that you can benefit from. Looking from another angle, if we are looking at the bigger businesses and you are considering a limited joint stock partnership, you would be glad to hear that you can have a single level taxation for unlimited partners, yet you have no healthcare contributions and you have unlimited access to profits. And you will also have an option to have access to these profits on the go. Obviously, these will all have to be taxed, but unlike in limited joint stock partnership, in, for example, limited liability company, you have a limited access to profits during the year. Only after the year end, you'll be able to pay the entire dividend. But during the year, you just have access to parts of it. So what to avoid under the Polish tax new deal? So high tax solutions, obviously. So when we are looking at different solutions, you have to consider, is there any other solution that will give me a lower tax bill? So if I can get a lower tax bill somewhere else, maybe it will be prudent for me to go somewhere else and to check something different. So sole trader with proportional healthcare contributions is one situation when you can see very high tax solution, because when you have the general rules applied, so you are seeing that 17 and then 32% personal income tax with 9% healthcare contributions. It's a huge tax bill, because it's a tax bill that's going to reach up to 41% of your net income. You may try to avoid two-level taxation. So you may not want to end up in a limited liability company if you want to have access to profits, because the two-level taxation will eat up a lot of them, unfortunately. You may want to avoid situations when you may not be able to get access to your money fast. So you have to wait, for example, for the dividend day, as I said, to get access to your money. So this is the things that you have to avoid. Another thing is that what I said before, it is hugely important, is of absolute essential importance to set up your business from day one the way you want it to be. Why? Because all the tax authorities are being attracted by change, or maybe so to say, all authorities are being attracted to change. So if you set up a business from day one as a given structure, it can also attract attention from authorities, but the change in itself will also attract their attention. So any tax-focused restructuring, in particularly, can attract their attention. Also, thing that we have to mention is that every tax-focused restructuring can be considered tax avoidance, and tax avoidance can be hugely problematic for your business and also for your finances. Because if the tax authorities are successful in claiming that your restructuring was basically tax avoidance, the tax bill can go through a roof, and basically all the restructuring can be set aside. So all that you have prepared and all that you wanted to benefit from will be simply set aside, and tax authorities can say, this is what we are thinking, this is what we think it should look like, and this is the tax bill that we think you should have paid. So plan ahead, start your business in the way that it should be set up. If not, be very, very careful when doing any tax-focused restructuring. Obviously, restructuring is a part of any business. You have to amend, you have to change, you have to adjust to business situations. Now it's more obvious than ever. But if you are doing that, if you are going through restructuring, and when one of the points of focus or your main point of focus is taxes or lowering the tax bill, you have to be very, very careful not to give the tax authorities any idea that you are trying to do any tax avoidance. Well, you have to also look and try to avoid choosing seemingly tax-effective solutions. So as I told before, when we are seeing sole trader, historically, well, just a couple of months ago, it was pretty easy. Most of the sole traders, they were using flat rate taxation of 19% with lump sum very low social security and health contributions. And if you check the internet, obviously it will be full of its ideas because it's a very recent thing. But you have to rethink it for 2022. So sole trader now who has 19% flat rate has also an almost 5% healthcare contribution bill. So all things considered, it's not 19% tax, it's 24% tax. Obviously, it's not that it will not be a good solution for everybody. We'll talk about that later. But you have to analyze. You have to check every time whether a given solution, a given measure, a given model is actually good for you. This is what I will repeat time and again today, that in every business situation is unique. Obviously, there are lots of that are similar. But each and every business situation is unique, and we have to have a structure, have a solution that is good for you, and that not is good for your friend, not good for from somebody from your family. Another seemingly tax-effective solution can be specific work contract. So umowa o dzieło. Specific work contract is a contract where there is no healthcare contribution. There are no healthcare contributions. There are no social security contributions. So it seems very nice, doesn't it? Unfortunately, it doesn't work well in all business situations. When you are trying to hire somebody to work for you, you have to consider that the specific work contract is exactly for that. It's for the specific work to be done. It's not for somebody who will be working for you month on month, for a year, for 2 years. This is something that we are dealing with the contract of mandate or employment contract, or if there is such a possibility with a B2B contract. So we are hiring somebody who is a sole trader, but we are not hiring. As a rule, we're trying not to hire people for a prolonged amount of time under a specific work contract, regardless of the fact that it seems a very cheap solution in comparison to other contracts. Also, there are other pitfalls with the specific work contracts. It has to be very specific on what we are dealing with, what this person is going to do, how it's going to be done, when this person is going to deliver this work. So as you can see, it's not that it's something that you should entirely avoid and you should entirely say no to, but it's something that you should be very careful when applying. Another thing, obviously, is the gray zone. As some tax advisors say, the most effective tax saving is not paying taxes. Obviously, this is a big joke because it's because it gives you a whole amount of risk. So you open with no paying taxes, no paying healthcare contributions or social security contributions, huge area of risk, and even more areas are being opened now when you're entering this gray zone in 2022. So this is another thing that you may see on the market, that somebody is not paying everything under a given contract, that somebody is paying under the table, that because of that, this or other person has lower rates to offer to your client, so your competitor therefore can offer a more competitive rate to your client. But this is something you should very much avoid, because it only gives you huge risks down the road that will not be easily addressed. Okay, let's move on to something more optimistic, so to say, so to the savings model. We are already now at Krakowski Ciszek, we are not now at 30 plus savings models. We have gathered them in a way, maybe obviously from the market. So this is what we see the entrepreneurs do and entrepreneurs implement. This is something that we sometimes tweak, we sometimes try to make better, make safer, and try to offer as solutions that can be implemented. But these are the things that are already being on the market. Some of these models are models that result from the Polish New Deal, or even already from the Special Act of 12 March. There are different types of models. We have models for the savings models for the companies, employees, contractors, for all types of businesses, basically. But it's not that all 30 plus savings structures, saving models will basically work for each and every business. Usually there's 2 or 3 that are very similar, optimal for a given business. But it needs and requires, obviously, considerations from your part, from the part of entrepreneurs, to decide for yourselves which of these savings models suit you best. Depending on the model, the savings models they focus on different areas. Obviously, for the workforce, they focus on savings in personal income tax and or savings in social security contributions and also healthcare contributions. So depending on the model, we can see that either it's savings in just in taxes, or the savings are in healthcare only, or security contributions only, or security contributions healthcare, and so on. So the mix is different depending on which model we are talking about. For the entrepreneurs, we are focusing on overall savings. So what's the most important, obviously, here is how much money is going to stay, because with the workforce, it's obviously that we tweak the regular situation to generate savings. You already know what your rates for the clients will be. Whereas for the entrepreneurs, we basically look on the entire business to see which part of the business we can tax optimize to gain the optimal outcome. Some of the savings give rather spectacular savings from the get-go. The others require more time. These savings models, they all come with some sort of risk, which obviously as we try to mitigate and we try to address in other ways. There are already, as I said, models resulting from the Polish tax new deal, or even models resulting from the Special Act of 12 March. But there are also different models that have been altered by either of these new laws. And today I will present just some of them to you, because we don't have time to go through all 30 plus today. So first one that I would like to talk about is help and save. This is a savings model that we developed under the Act of 12 March. So this is the savings model that is being directed both to help the refugees coming from Ukraine and also generate savings for the company or for the entrepreneur that decides to help. So it's basically, so to say, a win-win situation in this taxing and difficult times. So how do we help? How do you help under this help and save model? So you help by providing accommodation and food for refugees from Ukraine. So you provide accommodation, sustenance, you provide, so to say, humanitarian aid to them. You facilitate access to kindergartens and similar facilities for refugees from Ukraine, and you also provide work. In providing work, you will be also looking at different savings models outside of this help and save. But this is something that we'll talk about in a minute, and also we can talk with you in some individual sessions if you'd like. So, and how do you save? What are the savings here? So first of all, humanitarian aid, including accommodation and food, received by refugees from Ukraine is exempt from the personal income tax. So anything that the refugees from Ukraine receive from you, from entrepreneur, which is considered humanitarian aid, will be exempt from the personal income taxes. Another thing is that the humanitarian aid can be tax deductible for entrepreneur. Here we would be looking at something more complicated than simply handing out food and giving out accommodation. It would require some more structure, some work to be done to actually be able to have this cost of humanitarian aid tax deductible. But this is just to give you a general idea of how it's going to work, what is the end result here. Another thing is that entrepreneur can receive public aid for helping refugees from Ukraine. As we know, this being implemented by the Act of 12 March, person or company that is, or an entrepreneur that is aiding refugees from Ukraine is entitled to 40 PLN for every day for every person helped for 2 months. So this is basically gives you a general idea of how you can help and how you can save money at the same time. Because otherwise, if we didn't have this model in place, providing accommodation and food to your employees and giving them access to kindergartens would create tax on their side. Because anything that either the employee or the person that renders services under a contract of mandate receives from the entrepreneur that's hiring employee or that person would be subject to tax. So this is the first side of the equation. So this is first area when we are gaining tax savings. Another obviously is that you are keeping your tax deductible costs, and it's not that obvious every time that you are trying to help somebody. Sometimes you have to think about whether when you are trying to help somebody just to provide the humanitarian aid, whether it can be tax deductible costs, and their usual answer is no. But here, given the special measures of the Act of 12 March, it can be tax deductible. And then there is the public aid, which obviously will also go to the pocket of entrepreneur. True, entrepreneur has to make expenses to help, which is obvious, but then it will be received back through the public aid. There are also some measures that will help to lower the VAT, so value-added tax bill, at this model. And there are also some other entities that would be involved in implementing this model, not only the entrepreneur and the refugees from Ukraine, but this also always depends on how we decide to implement it at the end of the day and which of these measures, of this aiding measures, will be implemented. Also, there are some other elements, some other savings that we can add to this help and save model, especially when dealing with employees. Another savings model, and this is the savings model that has been with us for some time, is what we call an elastic tax residency. So the tax residency is obviously crucial whenever you are applying any taxes in Poland. So when we are seeking to apply the appropriate tax regime and tax rates, you have to know what is the tax residency. For the Polish citizens, it is quite obvious, but for the foreign citizens, such as the citizens of Ukraine, it was never obvious, and it was always a thing to be decided at day one when we are hiring somebody. It's also essentially applying savings models. When you have not figured out what is the tax residency of people that you are hiring, it's really complicated to then protect the application of given savings models. So this is something you have to be very careful to determine, and you have to continue actually to verify this tax residency status, especially when we are now in this time of war and when we have lots of movement of people and the uncertainty of the future. And this unfortunately also increases the tax residency related risks. So it will be now much more complicated to pinpoint the tax residency of different people, especially those who are refugees from Ukraine coming to Poland. In personal income tax, the tax residency determines whether we see the tax bill of 20% on gross income, or whether we see 17% tax bill on net income, or whether we see no personal income tax in Poland. So for those who do not have Polish tax residency and do not carry a tax certificate, that would be 20% on gross income. Those who become Polish tax residents, that would be basically the 17% on net income. And those who come to Poland with tax residency certificate and have, so to say, special situation, they can actually be exempt from personal income tax in Poland under certain circumstances. When we are hiring students, school students, university students, under a contract of mandate, and when the students are under 26 years old, then when they are Polish tax residents, we can actually have no tax at all too. We basically can have no public dues, because under the rules on personal income tax and under the rules on social security and health contributions, you can see that you can have total exemption from all the public dues. So there will be no personal income tax, there will be no social security and healthcare contributions. It seems very simple because it basically requires just two things: to just an age of under 26 and a status of a school or a university student. But in practice, it's a bit more complicated, especially when trying to determine and to keep the status of the student. So this is something that we discuss with our clients, and we discuss how to basically implement it. And also with the elastic tax residency, we help clients to implement this elastic tax residency model to make sure that the tax authorities will consider it to be well done, to the extent that we will not be questioning it. Another savings model is the unregistered activity. So we have obviously the sole tradership when we register to become a sole trader, and we have different types of savings when we can generate that. But there is also a type of activity when we don't have to register anything, and this is called the unregistered activity. It's not an employment agreement, it's not a contract of mandate, it's not a contract for specific work, and as I said, it's not sole tradership. It's something different. But what it gives us no social security contributions and no healthcare contributions. And it also allows us to pay personal income tax once a year. Another savings model is a foreigner's company. This is not a foreign company, so this is a Polish company, so company set up in Poland, but with foreign citizens as shareholders. Obviously, the Polish citizens can be shareholders, but they will not have access to so many savings as foreign citizens. So the basic idea is that shareholders render services to company in the capacity of shareholders. So they also receive dividends, but this is something else. This is basically they render services to company, which is basically quite individual, should be quite individual, and for that they receive remuneration. Again, as with the unregistered activity, we have no social security and no healthcare contributions, and the personal income tax is payable once a year. But this is for Polish tax residents. The foreign tax residents with tax residency certificate can actually have no Polish tax bill at all. Now we come back to the sole traders, and we can see that as I said before, when we are talking about sole traders, what tax solutions you choose basically depends on your business. So when you have high costs and obviously high income, but the costs are high comparing to your gross income, you should not go to the lump sum taxation, because if you go to the lump sum taxation, the tax base is your gross income, whereas under the general rules or the flat rate taxation in personal income tax, the tax base will be the net income. So with high costs, you would rather go to the general rules or flat rate taxation, because otherwise your margin that you are gaining could be eaten up by the lump sum tax if you go for the lump sum tax. With the general rules or the flat rate taxation in personal income tax, you have the net income tax, which means that the tax costs can be deductible from the tax base. So you can, as part of your expenses, unfortunately not all, there are some exclusions, but most of your expenses could become tax deductible costs that lower your tax base. So for example, when you have a production firm, or when you have trading business, then you would not be looking at the lump sum tax, but rather at the general rules under the PIT or the flat rate taxation. This also depends on how much you are gaining year on year. However, when you have low costs or no costs, or this is when you have intangible services business, so for example advisory business, then you will surely be eyeing the lump sum tax. The rates in the lump sum tax range from 3% to 17%, and the most usual, most common are the 15%, 12%, or 8.5%. The 15% is for the advisory, which is not done as a with most of the business advisory. The 12%, for example, is for the most IT people, and 8.5% is a general lump sum tax rate for all the businesses, for all the types of business that do not have a specific lump sum tax rate for them. When you have the lump sum taxation, you also can benefit from lump sum healthcare contributions. These are at the level indicated here, and these levels depend on the annual gross income bracket that you are in. So as you can see, there are lots of things that you have considered before choosing what type of tax you want to, or what types of taxation you want to use for your sole trader's income. And here is, I think, the sole situation when changing the way you are being taxed might not be seen by the tax authorities as something that is dodgy. You can change the way you are being taxed year on year. So every year, once a year, you can change it. And then you can benefit from different type of taxation. This is at least now how the things are. Maybe the tax authorities will change their approach and will consider that changing your taxation from, for example, lump sum to flat rate year on year is also considered tax avoidance. But we'll see whether it will come to that. And the last of the savings models for today that I would like to show you is the limited joint stock partnership. The limited joint stock partnerships historically were very tax effective. Then it changed, they stopped to be so interesting for the taxpayers, but now with the tax new deal, they again have become very, very much attractive. Why? First of all, we can have single level taxation for the unlimited partner, which would be dealing with 19% effective tax rate. The unlimited partner can receive additional remuneration for running the partnership, which is going to be taxed at 70% or even less of effective tax rate for the net income of up to 150,000 PLN per year. The partners at the joint, the partners and the shareholders at the limited joint stock partnership, they do not pay social security or healthcare contributions, and the profits are basically can be made available to you as you go. So you do not have to wait for the dividend day to pay out the profits out of the company. Moreover, corporate shareholders, so those who are limited investors in this limited joint stock partnership, can also benefit from the participation exemption, making the dividend basically free of tax. This is all that I have prepared for you today. I would like also to invite you to look up our book, How to Hire Foreigners in Poland, when we are already looking at the new law that came into force in March 2022. So it's something very fresh, and it's something simply out of the press now. I thank you very much for your attention, and I will now pass the floor to Katarzyna, who will invite you for the third part of our meeting today. So over to you, Kasia.
Yeah, thank you.
And thank you very much for your attention.
Thank you, Wojciech. Moving on to our last part of our today's meeting, I would like to take you outside of Poland, and I would my intention is, and I will tell you now some information about the situation of refugees, of Ukrainian refugees, among other EU countries, not only here in Poland. Also, I would like to tell you at the very end which measures and which potential problems you may have when you would like to relocate your business to Poland from the perspective of Ukrainian law. So, starting with the information about other European countries, Isa have mentioned at the very beginning of our meeting that we have this super extraordinary decision of European Union, the Council of European Union, regarding launching the directive regarding people escaping from war. This law, in terms of what is from legal perspective, it is a directive. So that means that each member state of the European Union has to implement it into its own jurisprudence and legislation. So it can be done in a very various way. And this is what we are actually experiencing right now. Which people and which groups of refugees are covered by this decision? This was already Isa telling you. But in any case, each member state of European Union has to ensure exactly the same rights to the specified categories of person, plus it can extend this protection as it actually wants. And this possibility, to some extent, has used Polish government by introducing our special act. For example, here you have this option to start a business activity as a self-entrepreneur. What Wojtek was saying you how to do it in a most tax advisable manner. There are some special groups which the decision of the Council of European Union has left as open, and here the countries may decide as they want if they will cover with this special temporary protection these groups of people or not. This refers, for example, to non-Ukrainian students, so third people being citizens of third countries studying in Ukraine, or those who come for short-time work to Ukraine, and when they were working there, the work has started. So each country makes decision on these groups by itself, and there is no general rule on this intra-Europe level. The very important thing is that the temporary protection under the directive means not only legal stay for people escaping from war, and here we are talking mostly about Ukrainians, but also it gives very clearly the right to work. So this is actually what each EU country shall ensure to the Ukrainians, or at least to the Ukrainians escaping from war. The very important thing, I'm sorry, very important thing is that this special temporary protection means that each person escaping from war and coming to various EU countries actually has to make the decision on his or on her own where he wants to stay for a longer time, because in order to have the temporary protection, basically you need to decide where you are using this system. It can be Poland or it can be any other country, but this decision has to be made, and this decision is put in the registration files by the given country. It is not like that you can use temporary protection in Poland and then move to another country and also have this temporary protection. If one person is registered and will be recognized as a temporary protected here in Poland, then such person will be treated as a, let's say, classic third party in another country. That means, at least in my opinion, that companies which are seated here in Poland and would hire the refugees under the temporary protection here in Poland actually will not have an option to move these people and post them under the directive 71 from 1996. And this, in my opinion, is shall be actually excluded. Please also note that also our Polish regulations are very much limiting the option to post anyone to another EU country, anyone who is registered here in Poland, for the simple reason that we have a regulation saying that if someone leaves Poland for at least more than 1 month, then he is using this temporary protection. That means that this person is losing the right to work legally in Poland after this period. For this reason, I believe that this is the posting of employees is actually excluded, unless we are maybe talking for very short time periods of time. This is what I'm stressing here is my opinion in general, just for the reason that also other persons and lawyers are thinking about this and are considering this as a very interesting and very important question. There has been, to my knowledge, there has been raised a question on that to the European Commission, asking if this directive also and the right to legally work for war refugees, if it's also covering the situation of posting of employees or not. Nevertheless, for the moment, there is no answer to my knowledge by the European Commission, but still we have passed this extraordinary act, this special act here in Poland, which, as mentioned, entails this regulation that after 1 month of leaving Poland, the temporary protections or status of a temporary protected person is unfortunately lost. So for this reason, I am afraid that the very short answer to the question if Polish employers may post Ukrainian employees specially protected would be actually no. As a rule, you have, as mentioned before, as a rule, each country is introducing the directive into its own legal system. And since, to my experience, most of the Polish companies are very much wishing to post their employees or send their employees to Germany. That is why I want to tell you in a bit more detail how how Germany is dealing with the Ukrainian refugees. A small difference towards this, what we have introduced here in Poland. People who were by the start of war, they were somewhere abroad, not Ukraine, but they are Ukrainians. They were, for example, on vacation. These people can use and will be temporarily covered by the government of Germany. Basically, in Germany, it's very important to remember that you have to have, or an employee, each person have to have something that is called, well, legal stay permit. It's called Aufenthaltsgenehmigung, and this document does not incorporate automatically the right to work. It gives the person the right to stay in Germany. If it should be also legalizing someone's work, it must be clearly stated there. And this is also what applies to Ukrainian refugees. Germany has its own regulation already. It's not nothing new. It already has the documents, special regulation on the directive regarding war refugees. This is the paragraph 24 of their. I'm not sure how to translate the name of this act, but it refers to exactly to the right of legal stay. This is the here you have in the presentation the name of this act, which if you are going to look look up on the internet, and you will under this abbreviation you will find it. Nevertheless, someone who wants to be specially protected and legally work in Germany needs to have this stay permit together with the right of work. What is very, very important is that you have to, or the given person has to ask for this permission for work. The Minister of Interior has released a special regulation on the 7th of March. And for example, he has stated there that persons who will be covered by these regulations are Ukrainians, including those who had their place of stay, regular place of stay, or who were legally recognized refugees in Ukraine. So even third countries citizens. Still, it is not considered, and it is still under question if people who are stateless or nationals of third countries, if they may also be recognized as temporarily protected by German government. This is not clear yet. And also those Ukrainians are covered by this regulation who legally stayed in Germany on at the moment when the war has been started. So these will be persons, for example, with biometric passport who were I don't know, visiting the family or being on vacation in Germany. This special regulation has been released and is valid until May 23rd of May. So that is actually the timeline that a given person shall use in order to think if he is using the special protection in Germany or not. What is very important here is that once you decide, you will also have the right to work legally in Germany, as this is what indicated the German Minister of Interior for the German authorities. So this is very important and very different from this what Germans were doing so far. So by registering in Germany, the work will be also legal and possible. So the given Ukrainian will have legalized his stay and also the work. But please remember that Germans are not giving up on verifying special professions. There is a bunch of so-called regulated professions where the diploma has to be recognized and verified if someone is indeed as qualified as the Germans would like him to be. This refers to such professions like lawyers, like medical staff. In most of these cases, you will have to have in order to work as I don't know, a nurse in Germany, you will have to have the diploma to be recognized and acknowledged by the German authorities. So that means that it's actually very time-taking procedure, and on this the Germans are not giving up. There is a very handy, I would say, portal for Ukrainian citizens being in Germany. This is called Germany for Ukraine. And here there is really a lot of information on the stay, on the social help, on the legal work, etc., etc. The amount of social help that a given Ukrainian can get in Germany, these are these numbers that I have indicated here. Well, this is a bit uncomparable to the 300 zloty that the Polish government is giving, but well, it's simply we don't need to convince each other that this is a very different economy from the Polish one. Nevertheless, please remember that once you want to start, or your employees want to start being covered by these special regulations in Germany or wherever else, they cannot have this protection in Poland. In saying this in other words, we can say that at the moment that someone will receive a PESEL number, so this individual identification number given by Polish authorities, that means that he cannot register as a temporary protected person and cannot use all these extra rights given by each country in any other country of European Union. So it will apply to Germany, France, Holland, or wherever. As regards the Netherlands, there is a very interesting situation because the Dutch government was thinking for a very long time what to do with the Ukrainian refugees, and they have released a law withholding the obligation to have a work permit for Ukrainian refugees, but it will be valid from 1st of April. So still there have to be a few days to wait. And for the moment, for now, for today, a Ukrainian refugee being in the Netherlands would need a work permit to start working. So as you can see, the countries are really very differently applying the directive, and they are recognizing these regulations very, very well. Maybe not with such open arms as we did here in Poland. This maybe I will say that this way. I see that there are some questions popping up on our chat, but to this I will get back shortly. First, I would like to finish my part by saying a few words about situation, a very practical matter as regards moving the business of a given person from Ukraine to Poland, or actually wherever else, because these are regulations of Ukrainian law. So as Wojciech was telling you about the Polish tax situation of such a person who would like to start to take up its business activity in Poland, I would like to address the topic that is of very practical character, but it has to be absolutely considered. Namely, there are some obstacles and limits as regards transferring of money. Well, in order to start any business, you need, of course, some kind of funds. And basically, there has been a Ukrainian law saying that the transfers abroad made by Ukrainian company cannot be of amount exceeding 2 million euro per year. Also, this limit was the same in case the transfer were done. Sorry, there will be it can be even transferred more money than 2 million euro, equivalent of this amount in any other currency. Over 2 million if the transfer were made within an intra-group. So if you would like to establish here in Poland a limited liability company or any other type of company, then you could have transfer even more than 2 million euro. Such limit for transfers abroad for individuals, it was 200,000 euro per year, but such transfer were not meant to sponsor business activity of this person. So pretty easy way to get away of this obstacle was to open a private business account here in Poland or wherever else, but as a private person, transfer the money to such a private person account and then use it for the business activity. So that was the practical and handy way to do it. Still, both these limits are actually put on hold, and they are no more valid for the time of war, as there was a resolution of the National Bank of Ukraine made at the day when the war has started, and not companies nor private persons can make transfers abroad. Money transfers abroad, unless they are these funds are devoted to buy equipment related to war, and there is a full list of things which are considered as such. So basically, despite this normal regulation, as mentioned here on the slide, this is no more valid for the time of war. Hence, the only option that stays to be applied is actually paying out the money from account in cash. Here, you have the limit of 10,000 euro that can be taken in cash on the border of Ukraine and used for any purpose needed. But you can even take more money as long as you can confirm with the documents where these money are coming from. So also if they were actually taxed. If these documents are provided, then it should be no problem with moving or taking simply with the person even more money than 10,000 euro. Another practical matter is that a withdrawal of money from a private account is for now it is limited to 900, equivalent of 900 euro, it's 30,000 of hryvnia. So well, an individual can take out the money from private account for a day in this limit every day. So as you see, for the moment, it seems to be the option to relocate the business seems to be, well, blocked, but it's not like this, that this is absolutely not possible. However, the only legal way to take out the money is simply transfer it in a, well, you can say in a backpack and transfer it in cash. And very practical hint is to take it together with the documents confirming where this money are coming from, that they have been taken out from a bank account in Ukraine. As regards a relocation of business, another issue has to be considered. It is actually a new law has been just passed, and it has been signed by the president, so it will be enforced in few days. And this is the law saying that normally, if you would like to relocate the business and change the one of the major employment conditions of an employee, namely to change his place of work or even country of work, you would need to give the person 2 months notice period to decide if he wants or not to go with your business, or he would prefer to stay in Ukraine. So this limit will be no more existing once this Ukrainian law is in force. What is important that when relocating the business, the salary must be paid at least of the same amount as in Ukraine, so it cannot be any lower. And if the employee refuses to be relocated together with the business, then the new law gives the right to terminate the contract of employment, but only if it's not possible to continue employment in Ukraine. So under these two conditions, the termination will be possible. I know we have extended the time of our meeting. I would like to, at the very end, to invite you to our other trainings. I will be and webinars. Me personally, I will be speaking in 1 week time, I believe, about the situation in Germany in more detail. But considering the fact that the German new regulations are actually meant for a pretty narrow group of people, please consider that the regular law is still existing and in force. And in this situation, the worst situation doesn't mean that previous law is not more applying to these people. So. Also, we have other trainings that you will find on our webpage, and I am encouraging you and inviting you to visit our webpage, also our LinkedIn profile and the YouTube channel. I will take a chance now to see what questions you have asked here.